Hello everybody. So in the last presentation we started talking about teachers and teachers' rights and teacher employment and teachers in the law in general. In this presentation we're going to kind of take a leap and talk about teacher dismissal and the rights involved when it comes to dismissing teachers. So as education is a state issue, it's no surprise then that conditions of employment are controlled by state statute, especially when it comes to things like tenure, what is tenure, or as we now refer to it as probationary and non-probationary status. Those things are in state statutes, and toward the end of this presentation, we're going to look at some state statutes in Oklahoma as far as some of the things that we're going to discuss in the presentation. There is also a distinction between non-renewal and dismissal. So it's important to keep this distinction because most of what we're going to concentrate on is dismissal. The non-renewal is simply not offering a new term of employment at the end of a contract term. When you're a probationary teacher, you're on probation or non-tenured, as many of you think of it. You are on a non-renewal contract, and we simply renew that contract at the end of the first year, at the end of the second year, and at the end of the third year, with the anticipation that you're going to gain tenure. Now, what I'm talking about is all predominantly going to deal with PK-12. Higher ed is a little bit different than this, and the status of tenure carries more weight when it gets into higher ed. But I just want to throw that out there. But non-renewal is simply not offering somebody a contract at the end of their current contract term. Dismissal, on the other hand, is removal from employment during a contractual term. And so a lot of what we're going to talk about is going to be dealing with dismissal. And the big thing that we're going to see here deals with due process. And due process comes into play when a teacher has a liberty interest or a property right involved. And we get this out of the case of Board of Regents versus Roth. The question here was, should this professor be let go, or should he be renewed even though he was non-tenured? And the courts ruled there was no liberty interest, there was no property right, and we're going to define those terms in a bit, so don't worry if you don't remember what those terms are. We talked about them a little bit during student right presentations. But the courts ruled that there were no property right or liberty interest involved, and so therefore due process was not violated, and you could simply release the person. And to reiterate, there was no property right, probationary status, not tenured. Property interest may be established if, so this is what we mean when we talk about property interest. If there is tenure status, if there's a contract, or if there's a legitimate or objective expectation of reemployment. So that's what would give him a property interest in the position and have a property right violated. So when we think of property, it's not just property in the sense of tangible things. Here the courts have interpreted property interest to these expectations that are legitimate expectations. So if you have a continuing contract, then what they're saying is that that continuing contract would give you property interest. Therefore, you would have to go through a due process procedure to have your position terminated. Due process simply means that in order to terminate you, there are certain steps that a district must adhere to before they can terminate you. So what this case is doing is it's setting out this whole process for us. If the property interest is there, if the person has a contract, if the person is tenured, or as we'll learn later on, if there's the legitimate expectation that the person is going to be rehired. All those things are property interest, and due process applies. They could not just let the guy go at the end of the year. And the court said in Roth, no, this stuff was not there. So that's a property interest. A legitimate or liberty interest deals with your reputation or your name and good standing. Okay, and the courts ruled here that there was no harm in Roth's reputations. It did not damage his standing or his good name and associations within his community, and therefore no stigma was attached to non-renewal. And that's the thing about a liberty interest. Liberty interest means that a stigma has been attached to your name, and now it limits your ability to go out and gain employment in your community or in your field. And it's not that that cannot happen, as we'll learn though, if it's there are lines where that can come into play. Talking about somebody, the biggest thing being whether it's true or false, but we'll cover that more. But that's what a liberty interest is. It's protection of your good name with the idea that you can go out and get employment in your community and or in your field. So Roth was 72. In 76, we have Bishop versus Wood, and there was more clarification on the idea of stigma. And the court said here, as long as reasons for non-renewals are not made public, then no stigma or infringement of liberty exists, even if the reasons are false. And here the courts use state statutes to decide the rights and interests. What they're saying here is basically conversations that you have, and we'll go into this a little bit more later on, but even if things said about you that could harm your name are said in a private meeting between you and your administrator, those things are not stigmatizing because they're not made public. And so therefore you have no liberty interest at that point. And keep in mind that North Carolina and Oklahoma are at-will states, and that basically means that while you have non-tenure status, you can simply be let go. Finally, under this piece of stigma, the due process clause of the 14th Amendment is not a guarantee against incorrect or ill-advised personal decisions of public employees. And there are some instances in the text, in Alexander and Alexander, where they talk about ill-advised decisions that people made, and the courts look at the magnitude of those decisions. But sometimes an ill-advised decision can cost you your position and not attach a stigma to it. Stigmatizing, if it is not made public, it is not stigmatizing. Okay, so things that are not stigmatizing: incompetence, insubordination, neglect of duty, things that would be considered stigmatizing: accusations of racism, emotional instability. And so these are things that it's going to be a delicate line when you're dealing with these things, and Alexander and Alexander do a good job of going into all these different areas here and what they are. But it's not that you cannot be let go for these reasons. It's just that these are reasons why a stigma could be attached to your release, okay, if these things were made public. So a lot of this then evolves around tenure. So let's talk about tenure in Oklahoma first. Okay, this has changed in Oklahoma in recent years as we use predominantly now probationary and non-probationary status. This comes from the teacher leader effectiveness evaluation, the TLE, or the TLE is the evaluation, 98% of the districts, more than 500 of the 515 plus or minus districts, use the Tulsa model, TLE. But just in case you're not aware, which I'm assuming everybody's aware, within the TLE, you're graded on various indicators using 5 categories: ineffective, needs improvement, effective, highly effective, and superior. And so now, with the TLE in full implementation, tenure and earning tenure has taken on a little bit of a different role. There are 3 ways that you can earn tenure in Oklahoma. And those are, for your first 3 years, if you received ratings of superior for at least 2 of the 3 years with no rating below effective, you can earn tenure. If not, during the first 4 years, you received average ratings of at least effective with at least an effective rating for the last 2 years, you can earn tenure. And if not, if you still do not meet it, and your administrators want you to remain in your position and gain tenure, because at that point, if you're going to remain in your position, you're going to get tenure after 4 years. Then it will take a letter of recommendation from the principal and the superintendent to the Board of Education, at which time the Board of Education can agree to give you tenure status. So that's changed quite a bit since when I first started teaching 20-some years ago. And that's been just recently that has changed. So how is tenure viewed as a whole by the courts? The first case we're going to look at, again, comes from the 70s. Again, keep in mind, this was the year of Roth. This case was handed down the same day as Roth, Perry versus Sinderman. And in here, we see a faculty member who was given de facto tenure. And what happened in this case was simple. The faculty handbook had a statement in there that said the administration wishes the faculty member to feel that he has permanent tenure. And the handbook went on to say that as long as the teacher is performing satisfactorily, the administration wishes that they feel this way. And the plaintiff in this case, I believe he had worked at the university for about 10 years. And so every year there was no tenure, but every year he was renewed. And he had criticized the university for an expansion effort, if I believe so. And as a result was let go. And he sued, saying that even though there was not de jure tenure defined by law, that this statement in the faculty handbook guaranteed that he had de facto tenure, in other words. And so there was that expectation. So earlier we talked about property interest and liberty interest, and in property interest we talked about tenure status, contracts, and the third one was the expectation. Well, here's where we see that expectation come into play. And because of the way the handbook was written for faculty and the way that the plaintiff was treated in this case, the expectation was there that he would have tenure, and that's why we see that third item under a property right, and that is the expectation of something, and in this case, tenure. So let's move in now to what tenure gets you. So the easiest way to say this is that a non-tenured teacher can simply be let go. As an at-will state, you can simply just not renew the contract. But what tenure does is tenure gives you due process. And that's a simplified idea of what tenure does for you, but it gives you due process. So it's a protection, in other words, because now the district cannot simply let you go. The district leaders cannot simply let you go. but they have to go through steps, formalized steps to let you go, and there has to be reasons attached to these. Whereas a non-tenured person can just be let go with no reason. Okay, so what these steps are, we call due process. So tenure gains you due process. And there are two types of due process here. The first type is the easiest to understand. It is procedural due process. And basically it talks about what the term infers. The procedures gone through to get you to take away your right. Okay. So again, the right here that we're talking about is your property right as tenure status or as under contract, or the expectation that you're going to have a job until you decide not to, or your liberty right, and that would be to maintain a good name and good character. So in order to take away those things now, the school district has to go through due process. And the first type here is procedural due process. So again, these are the formalized steps the district has to go through in order to take those rights away. And we'll look at what those steps are. And during instructional leadership, you will work on a plan of improvement which incorporates these steps in procedural due process. The second type of due process is a little bit more fluid as far as grasping the meaning, but we call it substantive due process. Here we're talking where it says the extent and nature of the content of due process. And basically what that means is we're looking at the case, whatever it is, the infractions the teacher's done as a whole, and looking to see that all that we're going through is a legitimate thing. There's a connection there. In other words, we're not going to dismiss a tenured teacher for arriving 5 minutes late to school and declare that teacher insubordinate and incompetent. That goes beyond the extent and nature of the whole due process procedure. Okay, so what we're doing is we want to make sure that during these removal of rights, that we're matching up and making sure that our infraction we've done matches the punishment that's going to receive. And all that falls under substantive due process. So let's look at some cases that deal with procedural due process and how it came about. Wrong way. So the first one here, Cleveland Board of Education versus Loudermill, 1985. Is going to implement two things here. That first of all, there has to be a pre-termination hearing where the teacher is advised of the charges against them, the nature of the evidence against them, and a chance to tell their own story. And that's going to be important as we go through. And when you do get to instructional leadership and you start working with your plans of improvement, all of this is really going to come into play as you do this, as you make that plan, because you'll see that these things are all put into place within that plan. Okay. The possibility of a post-termination hearing, I should probably delete that because our laws have changed quite a bit in Oklahoma since this was originally done. Due process steps then are notification, and these are the steps here. So when we say you violate due process, these are the steps. Notification of charges. The teacher must know for what reasons they are being dismissed. Opportunity for a hearing. The teacher has to have the opportunity to be heard, to give his or her side. Adequate time to prepare a rebuttal to the charges. Once the teacher is notified of the charges, there has to be adequate time for him or her to prepare a rebuttal against those charges. Access to evidence and names of witnesses. The teacher needs to know the evidence that's going to be used against him or her and the witnesses who will be speaking against him or her. Hearing before an impartial tribunal. Well, an impartial tribunal, and here's a court case here, Hortonville Joint School District Number 1 versus Hortonville Education Association. The question here was, most dismissal cases are heard before the Board of Education. So the Board of Education is acting as a part of the school. So can the Board of Education be considered an impartial tribunal? And so the answer to that question came in 1976 when the Supreme Court ruled mere familiarity with the facts of a case gained by an agency in the performance of its statutory roles, in other words, a school board acting as a school board, learns of what happened in the case, does not disqualify a decision maker. And so by this court ruling, what happened was the court said that the Board of Education can be considered this impartial tribunal. So that is why any hearings about dismissing a teacher where the teacher is going to rebut are going to be heard before a Board of Education. The rest of the steps in due process, the teacher has a right to be represented by legal counsel. The school board will most likely be represented by legal counsel if it gets to that point. The teacher will have an opportunity to present evidence and witnesses of his or her own. The opportunity to cross-examine adverse witnesses. Decision by the board is based on evidence and findings of that hearing. There will be a transcript or record of that hearing and an opportunity to appeal an adverse decision. Now, that has changed considerably in Oklahoma. The only way that you can really appeal a decision in Oklahoma now is if you can show that your rights were violated. Other than that, there is no way to appeal a decision. There used to be a way to appeal a decision in Oklahoma, but the law was changed and we did away with what was called trial de novo. And as a result now, the board is the final decision making, unless you can prove that your due process rights, whether procedurally or substantively, were violated. And that is why it is important that you as the administrator are going to document all these steps and have documentation as you go through. So that's due process for tenured. Non-tenured, if a non-tenured teacher's contract is not renewed and no reasons are given by the board, the teacher's constitutional rights are not offended, and the teacher has to challenge. But as an at-will state in Oklahoma, the idea that you can win that challenge are pretty slim. Okay, it's just not going to happen. In Mount Healthy School Board of Education versus Doyle, a non-tenured teacher may be non-renewed for good reasons, no reasons, bad reasons, or even false reasons. If the reason is unconstitutional, though, that is the only time that a non-tenured teacher can fight and maintain his or her job. But notice there it says even for false reasons. So the bottom line is that administrators do not have to give reasons for letting non-tenured faculty go. They can just simply let them go. Tenured teachers. Reasons why tenured teachers can be let go. And again, you will go through this process, that due process, those 11 steps that we talked about. The number one reason that tenured teachers are let go is incompetency. Now, incompetency, it covers a lot of things. And here are some examples. And all of these go back to specific cases. Okay? The lack of knowledge of subject matter. I tell people all the time that as a College of Ed, what we do is prepare teachers for the minimum threshold. Now, we have a lot of teachers, and we're very proud of them that go beyond that minimum threshold of what it takes to be an educator. But the basic goal of the College of Ed is that we get teachers to the minimum. The State Department, in issuing a certificate, is putting their stamp of approval that the teacher has met the minimum requirements. That does not mean the teacher knows their subject, his or her subject. And so therefore, that's a rule. If they don't learn it, you can get rid of them for incompetence. A lack of discipline in the classroom, unreasonable discipline. If you spank a child and there's no policy against that, if you yell at students, if you assign 10 days of after-school detention for throwing a piece of paper, those kinds of things. Unprofessional conduct, willful neglect of duty, using incorrect English, and there are examples of that, very good examples of that in the text, where teachers not only used incorrect spoken English, but consistently used incorrect written English in presenting lessons, and were let go for that reason. Poor teaching methods and failure to follow required pedagogy methodology. Those are all areas that fall under incompetency, and it doesn't have to be all of them. It can be one. And if you do it over a period of time, and we're going to see that in Oklahoma, we're going to help teachers try to improve, but if they ultimately don't improve, then we can get rid of them for incompetency. Not for nebulous. They cannot be let go for nebulous and uncertain evaluations. Typically, you're going to bring in teacher evaluations when you dismiss a tenured teacher. So keep in mind those things will be asked for as evidence most likely. And not usually for a single incident. We're going to let tenured teachers go for multiple incidences depending on the magnitude of the incident. Okay, now there are some things where we'll let somebody go immediately. But there are other things where it's a matter of building a process over time. For example, the lack of proper English is probably not a single incident issue where we would let a teacher go, but over time, if that did not improve, then we could put them down for incompetence and let them go ultimately. Expert testimony. The courts have ruled that expert testimony can come from principals, curriculum supervisors, other supervisory personnel on part of the school of why the teacher has exhibited incompetency or one of the other areas that we discussed. So another area besides incompetence is insubordination. Insubordination is the constant or continuing intentional refusal to obey a direct or implied order, reasonable in nature and given by and with proper authority. So this is a teacher who refuses to basically do what they're told to do if it's done in a reasonable manner by somebody who has the scope to give that order. In order for insubordination to happen, the board must be able to prove. Now notice where the proof of, or the burden of proof is here. Here it's the board. If we're getting rid of a tenured teacher, it's the board who has to show, or the administrator has to show insubordination. It's also the administrator has to show competence of that tenured teacher. If it's a non-tenured teacher and the non-tenured teacher feels that he or she was let go for unconstitutional reasons, then it's the teacher's burden of proof to show that. But most of the time we're going to see it's the administration who has the proof. So here we see that for insubordination to be adequate, the board must be able to prove the act happened. There must have a rule or evidence of order by a superior. In other words, what did the administrator tell the teacher to do that they did not do? Prove that the rule or order was violated, if the teacher did not do it. Prove the teacher did not try Success is not required. So that's a key one there, that it wasn't that the teacher did or did not try. Okay, let me rephrase that. We have to show that the teacher did not try. So if the teacher tries in a half-hearted effort, you're going to have to build up a case for that, okay, because they can simply say they tried. And building up your case would be, how can you help the teacher with this half-hearted effort become better? But success is not required. If the teacher can show that they tried, that's going to get them. The board must prove the teacher's motive was not admirable, must show harm from refusal, must show that the rule or order was reasonable, the rule or order was within the scope of the authority by the administrator, and the rule or order could not be biased or discriminatory against the teacher, and finally that the rule or order does not violate the First Amendment rights of the teacher. So that's a lot of things that we're saying the board has to show, or the administrator has to show, but really, as long as you pull out your personal bias against the teacher and are reasonable in what you're asking, insubordination is going to make itself known fairly easily. Another reason teachers can be let go is because of immorality. This includes both heterosexual and homosexual activities. But immorality is not just exclusively sexual activities. And we often think of immorality as being only sexual. And while the majority of immorality cases may be sexual, it's not that they all are. Okay. And Horosco versus Mount Pleasant Township, the court in Pennsylvania stated, the course of conduct as offends the morals of the community and is a bad example to the youth whose ideals a teacher is supposed to foster and elevate. This is an important statement for Oklahoma because while here in the Tulsa area we live in an urban and suburban community, not all of the state does. In fact, the vast majority of our school districts are out in rural areas. And so what they're saying here is immorality has somewhat of a fluid definition depending upon the community in which one resides. So here are some extraordinary circumstances brought to us by Alexander and Alexander that talk about examples of teachers being let go for immorality. And notice that they don't all deal with sexual activities. Brandishing a 12-gauge shotgun and a 38 caliber pistol and arrested for trespassing. These are teachers, by the way, who did these things. When it was found out the teacher did this, the teacher was let go, and the cause for letting go was stated as immorality. It was upheld. It was found out that a teacher had 3 drunk driving convictions and 2 driving without a license convictions, and the teacher was let go. Here's one where the teacher had asked to leave to go to a reading conference. The request for absence was denied. The teacher went. The teacher provided a substitute, and then I think the teacher came back and asked that those absences be excused. And as a result of that, everybody put together what had happened, and it was obvious the teacher had lied of why the teacher was gone and subsequently let go, and the teacher sued, and they said no, the lying was an immoral act done by the teacher, and therefore the release was upheld. Sexual misconduct. Teachers must be pure in intent and act when dealing with students. These are examples, again, from Alexander and Alexander that talk about sexual misconduct where teachers were let go. One was where a teacher tickled and touched a female student. Another was on a field trip where a male teacher was lying on bed with a female student. And another was where a male teacher had made sexual remarks and innuendos to female students. Unfortunately, it doesn't end there. Male teacher asked females to sit between his legs, kissed them on the cheek, stuck tongue in one's ear, and placed hand on another's breast. That teacher was let go. Another one, a teacher placed hands inside the jeans of a student in the buttocks area and squeezed the breasts of a female student, and that teacher was let go. Yet another, a teacher got a student pregnant in a prior school and was given a job in a new school district. And later on, the school district found out what had happened and why the teacher left the previous school district. And as a result, dismissed the teacher and let them go. And the teacher sued. And they came back and said that the dismissal was upheld because the teacher failed to inform the incident to the current administration in his current teaching job, and therefore he was dismissed. Another teacher, a male teacher, had a 14-year-old student come to his house, and while there, police came to look for the student, and the teacher hid the student from the police, and when that was discovered, the teacher was let go. Sexual misconduct with non-students. All those involve students, but not all the time do they involve students. Some of them are non-students. If the sexual misconduct with non-students can show that it impacts the teacher's fitness to teach, and whether it's public or private, if those things can be shown, then even sexual misconduct with non-students can be grounds for dismissal. The biggest thing here is really the public and private, and Alexander go to a lot of examples of the difference between public and private. And basically, public is where somebody can see it, and private is in your home. Not private as being between you and another consenting adult in a public place. That's obviously public, okay? So, keep those things in mind as you work with your teachers. Public lewdness. If done in public, this might be something. I can remember a case in Tulsa fairly recently where an administrator was let go for urinating in public. And as a result, that was held up. Okay, I don't even think there's probably any question there. Again, in the privacy of your home does not flow outside the house. So things you do in your home or your own business. It's when it's out in public that it becomes problematic. Another reason teachers can be let go are criminal convictions. If it damages the effectiveness of the teacher can be dismissed. Keep in mind, in Oklahoma, if you receive a felony, you will lose your teaching license for 10 years. If you are convicted of a sexual offense, misspelled there, you will lose your certificate forever in Oklahoma. You will no longer be allowed to teach in Oklahoma. Another reason, moral turpitude. This is in Oklahoma, and most states have a moral turpitude clause. Again, this is going to depend on the community in which you find yourself working and or living. An act of baseness, vileness, or depravity in the private and social duties which a man owes to his fellow man, which is society in general, contrary to the accepted and customary rule of right and duty between man and man. Again, this is kind of a sliding scale depending on the moral standards of your community, so that's important to keep in mind. What you might be dismissed for, or what might be permissible in an urban area with 3,000 teachers and 100,000 students, may not be acceptable in a rural school of 50 teachers and 600 students. So just keep that in mind. Types of moral turpitude found in the text: growing marijuana, conviction of mail fraud, shoplifting. Again, I can remember fairly recently an administrator caught shoplifting and was dismissed. Misdemeanors, a little bit more difficult to get rid of teachers for misdemeanors. You really have to show that it, again, damages the effectiveness of the teacher to do his or her job. And at that point, you can get rid of them for misdemeanors. But typically, you don't see teachers being released for misdemeanors unless it can be shown that the misdemeanor um, may have been a plea bargain or something to help the teacher. Drugs and alcohol. Oops. Again, this one's going to be pretty straightforward. This might be where you can get a misdemeanor, but through moral turpitude, it might turn into something that would impact your effectiveness in the classroom, and therefore you could be dismissed if you were caught with drugs or driving without a license or driving impaired and so forth. The example, we had that teacher who had some driving under the influence convictions. Finally, good and just cause. So this is kind of the catch-all then. So we have some specific examples of why tenured teachers can be dismissed. Keep in mind we're going to go through the whole process of due process, and it's going to be substantively correct to take away that property right of contract, and we're going to protect that liberty right of the good name of the teacher. So we had that whole list of reasons why, of things that we can dismiss teachers for, but here's kind of the catch-all if you have something that doesn't fit into that, the good and just cause. So some examples here. Falsification of test scores. In an era of high-stakes testing, a very important thing to consider. We saw this in Atlanta just a few years ago. Altering, backdating student files, especially dealing with special ed and special ed records so that they are compliant. Cohabiting with a teacher of the opposite sex. Again, that's probably a moral turpitude issue in certain communities. Speaking out about living arrangements. This would be speaking out about living arrangements, maybe talking about your partner and their numerous exploits, and that you need to stay with them for the sake of the kids or whatever. Okay. Violation of school policy, refusal to follow school orders, taking students to party where drugs and alcohol are used. All of those are things that would fall under the good and just cause reason for dismissing a teacher. Now, we have several slides here that talk about Oklahoma law, and I'm not going to go through all of these slides, but you can see here, I do want to point out some of them. You will have a copy of this presentation, so you can look at them all, but here are reasons a career teacher, tenured teacher, a non-probationary teacher, whatever we want to call them, him or her, can be dismissed. Willful neglect of duty, repeated negligence, mental or physical abuse, incompetence, instructional ineffectiveness, unsatisfactory teaching performances, commissions of an act of moral turpitude, or abandonment of contract. And then we can see that what I have here is going to go on and define a lot of these things. Again, I'm not going to read these. You can read them yourself. Here I'll point out that unless you can get the governor or the president to give you a pardon if you get a felony, you will be dismissed in Oklahoma. The same with the sexual offense. Failure to meet professional development requirements is a cause for renewal. These are those 15 hours a year that you're supposed to get. I've never known anyone not to get that. Moral turpitude is conduct contrary to justice, honesty, and good morals. The elements of intent knowledge are important, and if the wrong is unintentional, it is not moral turpitude. In other words, here we go back to that philosophical assumption of we're looking at the person's intent, and that's important here, that we have to look at their intent. That maybe something they did could be considered immoral, but it was as a result of doing something else, and that was not their intent. And so in that case, the person may have a legitimate claim if they could prove it was not their intent to do the immoral act, that it happened as a result of a legitimate endeavor on their own part. Again, we're not going to go through all these. There's the falsification of student records. Repeated tardiness of teacher can be considered willful neglect of duty. So here's what's going to happen once the teacher defines or figures out that they're going to dismiss a tenured teacher. Okay, and we will go through these here. When an administrator who has the responsibility of evaluating a teacher identifies poor performance or conduct that the administrator believes may lead to a recommendation for the teacher's dismissal or non-reemployment, the administrator shall do the following: admonish the teacher in writing and make a reasonable effort to assist the teacher in correcting the poor performance or conduct. And so these are things that you will do in instructional leadership when you actually admonish a teacher. At the point when we're talking admonishing means that we are giving them an ultimatum. You either do what we're saying here to correct the identified areas that are constitutional and legally give the district the right to non-renew you or dismiss you, or you get dismissed. So, admonishing the teacher in writing, make a reasonable effort to assist the teacher correcting performance. These are things that have to go into your plan of improvement with your teachers. Establish a reasonable time for improvement, not to exceed 60 days or 2 months, taking into consideration the nature and gravity of the performance conduct. I won't say most. I've done a couple of plans when I was an administrator, and in my instance, I probably put most on 60 days. One teacher, I thought it was more important that the teacher correct his or her problems, and I gave them 30 days. If the teacher does not correct the poor performance or conduct cited in the admonition within the time specified, the administrator shall make a recommendation to the superintendent for dismissal or non-reemployment of the teacher. And then we're going to go into some more legal things here, but I'm going to take all these legal things and put them into a visual representation. And this is just explaining what I'm going to tell you. Okay? So again, you can go through all these things here. So earlier we said there must be a pre-termination hearing. Here's what's going to happen in that pre-termination hearing for career or non-probationary teachers. The superintendent shall in person or writing specify the statutory ground upon which the recommendation is based, specify the underlying facts and explanation, and then the career teacher will have the opportunity to present reasons either in person or writing why the proposed action should not be taken. I had somebody ask me about closed sessions in boards. Closed sessions are to discuss personnel issues. So the board would go back into a closed session and discuss all these things. And then in an open meeting, the board has to vote in an open meeting on all things. They cannot vote in private on things. They have to vote in open meetings. So this is just explaining all of that. So let's get to the visual aid. So here you go. Reasons why teachers can be dismissed. So you see various things there. Mental or physical abuse of a child. Moral turpitude can automatically go to the principal recommending, the superintendent recommending it to the board sending notice out to the teacher, and then the hearing. The other areas, willful neglect of duty, repeated negligence, incompetence, instructional ineffectiveness, unsatisfactory, require the admonishment. That's your plan of improvement. And so basically what we're saying in Oklahoma is that when we identify areas in which a teacher is lacking, we have to do our best to help them in those areas to become what we expect them to become before the principal makes that recommendation. And so that's what you see here. Okay. If it's the moral turpitude or the mental or physical abuse of a child, you skip the admonishment and go direct to the recommendation. So what's happened at that point is the teacher is put on administrative leave. They will be continue to draw their salary until the hearing is conducted, and at that point, if they're terminated, their salary will terminate. So here is what happens then. A little bit more detail. The superintendent recommends to the board. Probationary teacher will give cause and underlying facts. The board sets notice of cause to the teacher, and the board has a hearing. Keep in mind that is not necessarily that does not have to happen by law. The career teacher side does have to happen by law. This is due process. The superintendent makes a recommendation to the board concerning career teachers and states the statutory grounds and the underlying fact. The board sends notice of cause to the teacher, and then there is a hearing. At the hearing, the teacher or the superintendent really presents the statutory grounds, underlying facts, and explanations of evidence. The teacher can then present his or her sides of why the proposed action should not be taken. And again, what we're saying here is that they have a chance to cross-examine, bring their own witnesses. Before this, they will have reviewed all the evidence and so forth. And then the board's decision is based upon the evidence that they hear during the hearing. And it doesn't matter anymore whether it's a probationary teacher or a career teacher. The board's decision is final. Unless that career teacher can prove that their substantive due rights or their substantive due process rights were violated, then they can appeal the decision. But chances are they're not going to be able to appeal that decision. So the things that go into an admonishment plan, these are the areas that you see in your plan of improvement. The employee, the preparer, most likely the principal, the date, the reasons, the purpose. The admonishment is saying you have until this date to correct this or you may lose your job. The area of deficiency, the description of the conduct or performance desired, it should say desired out there. Assistance provided, the timeline, the consequences, the delivery, formative conferences, and finally signatures. And so I'm not going to go again through all this. So let's do a quick review here of some of these things on teacher dismissal. We'll wrap this up. A reoccurring theme in case law concerning various acts that can cause a teacher to be dismissed is which of the following? Drinking and driving, damage to the effectiveness of a teacher, shoplifting, or insubordination. Damage to the effectiveness of a teacher. What we're saying here is that this theme of continuously using poor English can result in this damage to the effectiveness of the teacher, and over time can lead to dismissal. Which of the following amendments to the Constitution deals with due process and denying a liberty interest or a property right? One of the most important amendments we've talked about all semester, and that is the 14th. In which of the following cases did the Supreme Court rule that as long as procedural due process is properly carried out, a student can be dismissed from school for spiking punch at school? This is taking us back a little bit. This is Wood versus Strickland. Which of the following is not the granting of an employment property right past the length of the present contract? So which is not giving a property right past the length of the present contract? And the answer there is a temporary contract. In other words, temporary contract does not grant somebody a property right. They cannot expect that temporary contract to be given every year. Of the following, which best describes substantive due process? Steps taken to keep governmental will on subordinates instead of a boss's will. Steps taken to provide notice and opportunity to be heard. Legal steps that must be taken in order to provide a fair hearing or none of the above. And here it is steps taken to keep the government will on subordinates instead of the boss's will. That's just another way of saying what we said earlier, whereas the scope of punishment needs to match the crime or the infraction which the teacher is being admonished for. Of the following, who has the greatest due process if terminated? A career teacher, an administrator, a bus driver, or an entry-year teacher? Well, a bus driver and an entry-year teacher are on non-renewable contracts. In Oklahoma, an administrator does not have tenure status. Therefore, he is not, or he or she is not guaranteed due process. So the answer then is career teacher. According to the text, of the following which is not stigmatizing, even if made public. So, if we talk about somebody's emotional instability, their incompetence, or they accuse them of racism, all of them are stigmatizing if made public, except incompetence. Okay, if that's made public, it's not stigmatizing. Which is the maximum time in months in which Oklahoma teacher admonishment can be conducted? The answer is 2 months or 60 days. Which of the following is not an Oklahoma statutory ground for dismissal of a career teacher? Dismissal meaning leaving at that moment, or getting rid of them right then. In Oklahoma, it's insubordination. Which of the following is not an example of immorality? Being pregnant and unmarried is not considered immoral. Upon felony conviction in Oklahoma, a teacher will lose his or her teaching certificate for how many years? The answer is 10 years. A few more. Under federal case law, due process is required for extracurricular activities in Oklahoma. In other words, to take away a coach's coaching duties. The answer here is false. That is why you have different contracts. Now, you may sign them all at the same day, but you have a contract for you as a teacher and you have a contract for you as an extra duty contract. Those extra duty contracts do not have any kind of tenure status attached to them, and therefore due process is not required, and those extra duties can be taken away as fast as they are given. An extra duty contract grants a property right of continued employment. Just as the previous question, this is also false. If reasons for a non-renewal of a contract are not made public, there is no infringement on the person's liberty interest. That is true if it's not made public. If a teacher does not satisfy the stipulations of an admonishment, another admonishment by the principal is allowed to correct the same issue. Legally, that's false. Technically, I've done it. Okay? But again, and I don't know that the second one would have ever even held up in court if I didn't do the first one. But the goal is not to get rid of the teacher. It might be for a few, but in general, it's not to get rid of the teacher. Therefore, we want to help teachers as much as we can. When dealing with the termination of a career teacher, the decision of the board is final. And this is now a true statement in Oklahoma as of a few years ago. In Oklahoma, classroom teachers can be given a type of tenure called career stability, and that is false. So that's kind of a long look into dismissal. A quick 15-second overview, dismissal of a teacher. The big thing deals with tenure status, whatever you want to call it, career status, non-probationary status. Once that status is granted, then the district has to go through certain steps called procedural and substantive due process to take away those liberty, interest, and property rights that that teacher now enjoys. Otherwise, without that tenure status, a teacher can simply be let go. So that's a fast review for kind of a lengthy lesson, but hopefully you got something good out of that.